What is the duty of fair representation? The duty of fair representation is a legal obligation imposed on labor unions that act as the exclusive bargaining representative of employees. In simple terms, it means that when a union represents workers in negotiations with an employer or in handling grievances, it must do so fairly, in good faith, and without discrimination. The union cannot favor some workers over others, act arbitrarily, or handle grievances with hostility or bad faith. The origins of the duty of fair representation are rooted in U.S. labor law of the 20th century. When Congress passed the National Labor Relations Act, NLRA of 1935, it created a system of exclusive representation, meaning that if a majority of employees in a workplace voted for union representation, that union became the sole bargaining agent for all employees in the bargaining unit, including those who chose not to join the union. While this system promoted stability and efficiency, it also gave unions great power. Courts developed the duty of fair representation as a safeguard to ensure unions use that power responsibly. The Supreme Court formally recognized the doctrine in Steele v. Louisville and Nashville Railroad Company, 1944. In that case, a union representing railway workers negotiated a contract that discriminated against black employees by giving preferential treatment to white workers. The court held that because the union was the exclusive representative, it had a duty to represent all workers fairly and without discrimination. This landmark decision established that unions owe equal loyalty to every worker in the bargaining unit. The duty of fair representation has three central components. No discrimination. The union cannot treat employees differently on the basis of race, gender, religion, or other protected categories. No bad faith. The union must act honestly and in good faith, not motivated by hostility, retaliation, or personal bias. No arbitrariness. The union must make decisions rationally, not carelessly or without reason. While unions have some discretion and strategy, they cannot ignore grievances or handle them in a perfunctory manner. To illustrate, suppose a union declines to pursue a worker's grievance against an employer for wrongful discipline. If the union makes this decision after a reasonable investigation and concludes the grievance lacks merit, that is usually not a violation. But if the union ignores the grievance altogether or refuses to pursue it simply because the worker is unpopular or not a dues-paying member, that could violate the duty of fair representation. This duty applies both during collective bargaining and in the grievance and arbitration process. For example, a union cannot negotiate a contract that benefits one group of employees while intentionally disadvantaging another based on discriminatory motives. Similarly, when processing grievances, the union must treat each case with a baseline of fairness, even if it cannot pursue every claim aggressively. A curiosity about this doctrine is how it balances union discretion with worker rights. Unions are not required to win every grievance or achieve perfect equality. They are allowed to make strategic compromises, prioritize certain issues, and allocate resources as they see fit. Courts recognize that unions function as political organizations, and some workers will inevitably disagree with their choices. The duty of fair representation ensures fairness and good faith, but it does not eliminate the union's discretion. When unions breach this duty, affected employees can bring a duty of fair representation claim against the union. Often, such claims are combined with lawsuits against employers for violating the collective bargaining agreement, creating what is called a hybrid Section 301 action under federal labor law. Remedies may include damages, reinstatement, or orders requiring the union to process a grievance properly. In conclusion, the duty of fair representation is a cornerstone of modern labor law. It ensures that unions, as exclusive representatives, use their power fairly and responsibly, treating all workers in the bargaining unit with equal respect and good faith. Born from cases like Steele and refined through decades of labor disputes, the doctrine balances union autonomy with individual worker rights, protecting fairness in collective bargaining and grievance handling. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.